We're on section 2 in remedies, which gives us an opportunity to talk a little bit about some more modern procedural statutory remedies that are available, which we don't really, I don't think we study that much in law school at all. We tend to study torts and contracts, and we study property law, sort of the general notion of it. But a lot of times these days there are wrongs done to people, whether they're sexual harassment or discrimination, accommodations for people with disabilities, which is today's discussion is about. But there are both state and federal protections for certain violations of the law, and that's not something necessarily that you're going to learn in law school. You're going to have to figure out when the client comes in to you and tells you what problems they have, that there should be some law beyond sort of that general notion of what's a contract and what's a tort that you're going to be exposed to. Whether it's sexual harassment, which is governed potentially by both state and federal law, usually it's a state law issue, and that there are remedies with respect to agencies and the like that you would have to file that with. The one thing you should be aware of with respect to disabilities, with respect to harassment, with respect to other issues, these statutory remedies may well have a very limited lifespan for you to be able to file that claim. For instance, a claim of discrimination in Massachusetts must be filed with the Mass Commission Against Discrimination within 300 days of the last action. And the problem with that is that it's not really that easy to even think of it as 300 days from the last as making it timely, because the argument is that if you want to recover damages, the damages that are recoverable are only those then that occurred within 300 days prior to filing. So there's an argument that if you suffer this experience at work for more than a few years and that causes you a whole bunch of damages and injuries, that at some point what you can recover for is only that's within the statute of limitations period, which means you better have some acts and some damages within those 300 days of filing, because the argument may well be, and it is, it's a reasonable argument and the court will accept it, that anything before that is untimely. So what I want you to start to think about, especially with some of these statutory remedies that we look at, that the time period may not be years. We tend to think of statute of limitations in the form of years, right? 3 years for torts, 6 years for contracts, but there are the statutory remedies oftentimes, certainly for discrimination, harassment, and things like that, may well require you to file significantly earlier, and we're talking days, not years, with those agencies first before terminating any such claim and filing suit. You don't necessarily have to wait for the MCAD to dispose of the case, because that could take forever. But you do have to file there as a precondition to filing suit your claims of discrimination. Let's talk a little bit about the Americans with Disability Act and focus on the cases that we've got here, which are McGinnis, Toyota, EOC, Perez, and the early case of the professional golfer, Casey Martin, who wanted to receive some accommodation from the PGA for his disability. As you could tell from the cases, the ADA has been somewhat in flux since 1990 when it was first adopted. President Bush saw it as, what was the description at the time, was the civil rights for the disabled. And since 1990, there's been some modifications, the most recently being, as of, again, in January 2009, additional changes went into effect, and as the article I gave you talked about, subsequent to those changes, there's been an increase in filings And I think in part that was in response to some of the cases you're going to read tonight. Certainly the Toyota case, while still legitimate law in some ways, I think Congress was concerned, advocates for the disabled were concerned that Toyota might have gone too far. So we can talk a little bit about that as well. But I guess my first question is, in order to be covered by the Americans with Disability Act, which is a federal statutory act, what must the person show in order to be within the coverage of the act? Go ahead.
They had to show that there was a disability that substantially limited their everyday lives, or everyday lives in general.
Okay, so they have, did you say a substantial disability? You said they have a disability that substantially affects or limits their everyday activity. Anything else? Is that it? So any disability? Go ahead.
It can be either a physical or a mental impairment.
Okay, physical or a mental impairment that substantially limits a major life activity.
And that because of that, that he or she is entitled to reasonable accommodation.
Because of their disability that substantially affects a major life activity, they are entitled to reasonable accommodations in order to accommodate the disability. So do we have a separate definition for disability, or it is a disability if it affects a major life activity? And then we can talk about when we say major life activity, what do we mean by that? And as Karen points out, it's a physical or mental impairment, right? So it can be mental and still covered as a disability, or it can be some form of physical limitation. Is that the definition of disability? Is it an impairment? Go ahead.
Well, there says there's 3 factors to look at whether to constitute a disability, so that the nature and severity of the impairment, duration or expected duration of the impairment, and the permanent or expected long-term impact of the impairment.
Okay, so the disability really is at least in part defined by looking at what it impairs and to what extent it impairs that major life activity. So what is a major life activity then?
Walking.
Walking.
Talking.
Running, talking.
Eating.
Eating.
Hearing,
Sleeping.
seeing.
Seeing. So, like, fundamental. Learning. Yeah?
Yeah.
Learning's in too.
Wait, that's-
Walking, talking, seeing, eating, learning. So those are fundamental ways in which we live. It's got to be to that extent. I mean, that's what it means?
that the
I can
impairment-
walk, but I walk slow. Is that a disability?
No.
No, it's not. You walk slow, Fiona, do you? That's not a disability. I mean, is that what it is when we talk about that it substantially limits one or more of a person's major life activities? We mean it must be substantial, a substantial limitation, right? We're going to look at the cases in a minute. Because Toyota really helps to push, substantially limits quite far, I think, when we start to think of it. It talks about being determined on a case-by-case basis, so that means it's a fact-intensive inquiry for whoever raises the issue. We're going to see on a person-by-person, case-by-case basis whether they have that disability that impairs that major life activity, right? What's this part here in the Perez case? It talks about it's what we already decided. It's a physical or mental impairment that substantially limits one or more of a person's major life activities. 2, a record of having such an impairment, or being regarded as having such an impairment. So I wonder what, I mean, like if someone breaks their leg, but the leg will heal at some point. Is that a disability even though it's temporary? And they don't have a record of, I mean, you don't, at some point you don't have a record of having such an impairment. You have to establish the record. Go ahead.
They actually went into talking about the regarded as theory a lot. And from what I understand, especially in the Perez case, they were talking about how even though her disability, I guess, ended when she recovered, she was saying that her superiors were still seeing her as disabled and were treating her as that. So she used the regarded as theory, I guess, too, in her claim. So
if an employer or probably an educational institution regards someone as disabled, then that would satisfy that requirement potentially as well. So either you have to have one or be regarded as having such an impairment.
Right, being treated as though you still have it.
Okay, and in fact, the Perez says, well, she wants to deal with the regarded as disabled theory, but she hasn't identified what it is. What was her disability? How did it substantially limit that major life activity that we know has to be at least a part of precondition to be able to see if there's somehow a violation of the statute. The case that we've got from the articles is Casey Martin, who wanted an accommodation from the Professional Golfers Association to play golf, but in order to play golf with the PGA, you don't get to use a cart, you have to walk the holes. And the PGA raised various arguments about why they shouldn't, that's not, they shouldn't have to accommodate his disability. But if the PGA is a place of public accommodation, shouldn't he have gotten a card? No? Go ahead.
It makes the playing field unlevel. It gives him an upper advantage when playing golf for taking the cart. It's a time, it's not necessarily a timed event, but from getting one hole to the next, you have more time to concentrate, you have more time to focus, I would say.
But does that give him an advantage playing this game simply because he gets to use the cart between holes? I mean, what is his disability, first of all? Does it substantially limit some major life activity?
Yes.
Well, what's his disability? I don't think it's a heart. Blood disorder in the leg. So then what can happen to that leg? It potentially can be amputated. He can harm himself, but he wants to play golf. The question is he otherwise qualified as well, right? So he says, this is a reasonable accommodation. Let me move from hole to hole by use of a cart. PGA says, A, you're not sufficiently disabled. B, I'm not sure it substantially limits a major life activity. C, we don't have to accommodate you at all. And D, this isn't reasonable. So, are we all satisfied that he has a disability which substantially limits a major life activity?
Yes.
And that major life activity, just so we're clear, is walking, right? He does have a disability if he tries to walk. He can't walk that far on that leg, and certainly walking 18 holes of golf, he would be at least, and I don't think anyone disputes that, he would be risking his life if he did so, or certainly risking the limb. So he's got a disability. It does affect the major life activity. Now we get down to, is this a reasonable accommodation? What do you think? Go ahead.
Well, it was when I first started to read the case, I felt that he shouldn't have the golf cart. And then as I read it, I changed my opinion. But I also changed my opinion based on the argument whether or not this was a public accommodation. Because I thought that was really the crux of the case. Because I didn't think it was a public accommodation, you know, and I think that argument could go either way, you know. But that's how they convinced me. They did convince me that it was, you know, that it was a public
place of public accommodation,
yes.
a golf course.
Yes, and on that, you know, and I don't think it really did affect the game when they explained how, you know, he did have to walk. He still had to walk.
But he doesn't have to walk nearly as far as some of the other golfers.
But the other golfers didn't object to it. It didn't bother them that he didn't. They walked. They said really because of choice. And when you and if they do truly look at this as a case-by-case basis, then I think that it can work, which is what the statute says they.
But how do you respond to the argument that, well, now one player, certainly if they played 36 holes of the day in the hot southern sun, one of these players doesn't have to walk nearly that far. How do you guys know how long does it? Was 8? How long?
It's 5 miles.
5 miles. So you're walking. One player is going to end up walking 10 miles over the course of those 36 holes, and another guy gets to ride. Does that alter the playing field?
On page, well, it's 5 or 7, I printed it out, but basically they actually refer to that argument, saying that he has a greater advantage. They argue by saying that he presented evidence stating that basically even though he was using a cart, Martin would still walk during the 18-hole round, and that the fatigue he suffered was greater than the fatigue that the competitors were suffering, and he still had the pain even though he was in the cart. So it almost leveled out, I guess, their advantages.
So go ahead. What were you going? Go ahead.
Yeah. In this case, it was reasonable. In another case, it might have been a competitive advantage. But I think they said something like 1/3 of the time he walked about 1/3 of the amount that the other players walked, so he was still walking. And
with respect to his physical limitations was so much greater that at the end of the day, the test is about the same. Are you comfortable, though? Are you all comfortable that this doesn't change the nature of the competition? I mean, one player. Go ahead.
I was going to say, along the same lines that other people were talking about, they had an expert on fatigue who said most of it is a psychological phenomenon, so it has to do with the stress and motivation. So his isn't changed whether he's walking or in a cart. The whole idea of golf has to do with concentration and things like that. So a critical factor wasn't them walking, it was fluid loss, and he's still going to be in the sun and hot, but it mostly has to do with stress and things like that.
Well, but if he has to walk only 1/3 of what the others are walking, is that no competitive advantage?
Well, but that third is comparable to their full walk. That's what they're saying. You know, because it isn't there.
But isn't the nature of athletic competition that we will have differences among us, and the superior athlete gets to win?
But his athleticism is based on his ability to hit the club, not on his ability to walk.
Well, so you don't buy the PGA's argument at all that at least the walking is part of the athletic competition as well?
No.
No. No one accepts that?
It's part of the endurance.
You think it's part of the endurance? So, and if you can't do that?
Yeah, I mean, I hate to say it because I feel bad for the guy, but I just really think that it's setting up a dual standard.
Well, what about that? I mean, it does set up a dual standard to some extent, doesn't it?
Well, I have to ask a question because I don't know golf very well, but do you have to walk at a certain pace?
No.
Right, so you can take the longest amount of time and you're not overexerting yourself compared to someone who walks faster, so I really don't think the walking has anything to do with it.
And plus, if anything, it would slow the other people down.
Well, it would potentially. But don't they get to set their own rules for the contest? Well, that's where the place of public accommodation comes into play.
And that's where they lose the right to set their own rules.
Because they are a place of public accommodation subject to the same federal statutes that we all are. So once they are, now we can say, well, now we've got to decide whether that's a reasonable or unreasonable accommodation. And most feel that, well, that's just going to get us close to even. You don't, right?
Yeah, golf, having a cart is a blatant luxury in golf. It really lessens the fatigue that you play mentally, physically, altogether. I mean, if you were to give him or Tiger Woods the card, there'd obviously be a difference in performance and play.
What about that? Okay, so the average player is one thing, but if we give a superior athlete the card, well, they're likely to play even a little better. Certainly, again, depending on how long the day is and how many holes we have to play.
But isn't that the same argument in education?
Isn't it?
Yeah, I mean, isn't that the same thing? I know, if a student with ADD gets longer to take their exam, if they do longer, I think I would arguably do better. Not
Hopefully.
No,
but
I'm not me specifically, but any student. So isn't that the same argument that we use with any disability when we're giving them accommodation?
Well, what about that? I mean, to some extent, changing the playing field, whether it's on the golf course or in a law school or med school, right? You read McGinnis, which we're going to talk about.
Right.
And by the way, do you feel any differently about McGinnis than you do about Tiger Woods? And I see you nodding your heads. Why? Why? Because now this person's going to operate on you?
Yeah. If he can't stand the pressure and anxiety of taking a test, I don't want him operating on me. He's going to have some anxiety.
Oh, so this is just golf, this is a game. But listen, if you're going to start to do it where it gets really serious, then I've got some problems with this.
And also, he went through undergrad and graduated by coping with his disability. So how is this, how is this different? Why is he now raising this claim? Because medical school is harder than undergrad, and some people can do it and some can't.
He appeared to be using it as an excuse for his performance, while here it wasn't an excuse.
Well, why? Because you say it's so? No, because we do believe his claim to a greater extent than we believe McGinnis's. McGinnis, they gave you a couple shots. We don't all get to be lawyers. We don't all get to be doctors. Move on. And we really don't necessarily want doctors who aren't on the ball touching us. And we may not want lawyers like that either. No? Oh. So, I don't want, remember the, what was it, what's wrong with Joe Pesci? My Cousin Vinny. You might take Joe Pesci, you certainly don't want the other lawyer that was with him at the start, right? So is that what it is? We're going to change what we will do for reasonable accommodations depending on what it is we're asking? Or no, McGinnis is a pretty straightforward case.
Well, didn't they say that he failed to prove that he had a disability? It didn't meet the definition of disability under the ADA?
I think that's correct. I think that is right? That what? So McGinnis we can get rid of earlier because, and that's at least in part it's right, Fred. He was in medical school. Mr. McGinnis experienced anxiety in chemistry and mathematics courses. Okay.
Yeah.
No, right? I mean, geez, I have anxiety professor in my con law classes and problem. So what? I mean, that's what it is? Is that, and that's what Karen said, is we don't accept this as readily. He developed study habits that allowed him to overcome these difficulties in college. And during his basic biochemistry course in med school, Mr. McGinnis informed the professor of his anxiety, indicated he needed no test-taking accommodations, only that the professor set clear grading standards and not regard him as lazy. And as it turned out, that the whole thing didn't work out so well. So the fact that he toughed it out and tried it, we're going to then hold it against him when he says, well, maybe I was wrong. I do have a disability. My disability is learning. And I'm looking for a little bit of help here. Go ahead.
Well, I mean, the fact of the matter is that you have to, the case brought out, you have to master a certain material to go to the next level. And he wasn't just completely out. He had the option to repeat his first year. So he had another chance. He chose not to go that route.
And is that well, is that really important to us? And I'm not so sure it's not important to me either. I don't mean to say to minimize it. But geez, you did have they did give you an additional opportunity, and at that point it's your choice. Go ahead.
Plus, he was given an accommodation. He was allowed to take one of the tests 3 times and got the same marginal score, I guess. So what other accommodations could they provide besides writing the test for him?
Well, they could pass him, right? They could pass him. No, I think, well, what else do you think he's looking for? He doesn't want to take the whole first year again. Maybe, I guess, he might accept taking the course again, but like you, he might like to waive out of property, right? So, but are you saying no, there's some fundamental requirements of what we expect lawyers and doctors to do, and the fact is you can learn, but maybe not everyone gets to be a doctor or a lawyer. Maybe he doesn't have a disability at all. My guess is if I had biochemistry, I would have a lot of anxiety and do poorly in the course as well. So there's no disability at all?
No, with the
Go ahead.
learning disability, you have a history, or one would think you have a history, at least now when they have 504s written in schools and stuff, you have to prove, what led you to this point.
But so then you want to see in these cases that someone show that history of disability. But there's an awful lot of cases where that goes undiagnosed for ages. And then it's only, later on it's just have to figure out how you learn and how the thing you say, well, geez, something just isn't right here, right? Or I don't understand why. I had someone asking me about, they say I'm dying on these multiple choice questions we use it in comp. And I don't know whether that's, and I don't think it is, but sometimes you don't recognize a problem until later on, or others don't recognize it. And if you don't have a history, that's one way we can throw your claim out and say, look, I'm sorry, you should have shown up before now, that even if you had some issue, you got through college, you got through high school, you got through college, and if you're finding med school difficult or law school difficult, join the club. And maybe that's where McGinnis is at, is that he's done well, he's having difficulties in a very difficult program. Some people will. That doesn't make it a disability. What is the disability? And by the way, would learning mean learning, period? I have trouble in my biochemistry and chemistry classes and physics classes. Well, you can learn poli-sci, and you can learn sociology, and you can learn all those other things. Who wouldn't have trouble in physics and biochemistry and chemistry? That doesn't mean you can't learn. It means that you have difficulty learning really difficult subjects. Go ahead.
Or like certain subjects. Like if you have a learning disability, then it's generally like not in just one particular area. It's a general disability. Like some people have a hard time taking tests or something like that. Where in this case it was just chemistry and physics. It's a particularity.
Well, his is kind of narrow. I have seen one time, and some of you probably suffer this as well since you're in law school, I've seen it described that there can be, or at least alleged to be, that there's a learning disability with respect to mathematics, right? That we have a much more, right? And some of you probably don't care much for math. And so that I've seen that described as a particular subset of a learning disability that with the mathematics, that can be seen by some as a learning disability in that area, and there's probably more than a few people that have either a math phobia or problems with math that go beyond just I hate doing my numbers. It's that there may be something organic or whatever.
I would just say that if that's the case, then you probably shouldn't be a mathematician because I mean we
find something you're good at.
Yeah, find some, or not even something that you're good at, but something you can cope with. Like accommodations would have been better suited in undergrad so that you could pass math, because everyone has to pass math class or something like that. But getting into the highest math courses when you have a phobia of math or when you can't take any type of a math class is not a good idea. And we shouldn't just allow someone to graduate as a mathematician just because he has a disorder with math.
But we can let someone try to be a professional golfer even though he can't meet one of the fundamental requirements of what they say is the sport, which is to walk between holes. Because golf is a little more frivolous? No, or it's a game, it's not really, it's not the person operating on it, who cares whether he gets that card or not?
What if we look at it as they did in the case between reasonable and substantial accommodation?
Okay, tell me.
And isn't that what the difference is? We're allowing the golfer to, it's a reasonable accommodation to give him that golf cart. But to push this fellow forward would be substantially accommodating.
It's not a reasonable accommodation.
It's not
Well,
reasonable.
by the way, do they, in McGinnis, are they able to get past the requirement that the physical or mental impairment must substantially limit one or more of the major life activities of the individual? Right? I mean, because in order to get to what the accommodation is, and I think that was the easier part in Casey Martin. I don't think any of us would disagree that limb poses a major disability for him that absolutely affects a major life activity as well. But because McGinnis talks about in pretty stark terms that major requires that the activity be significant in order to be covered by the ADA. And then it goes on to say, and this is page 79 of the original decision, the regulations illustrate the meaning of major life activities, such as, by the way, I want to talk about a little bit about that in a minute, with such examples as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. I mean, these are the core activities that we use to live. This doesn't say, you know, I can't see. Well, it does really say you can't see. That it's not just, I have a little blur in my vision. Well, you can see though. And you can hear, even if you've got limitations to that. This goes to the core of you must not be able to do these things. And he can care for himself. He can perform manual tasks. He can walk, he can see, you know, and he can learn. But as you guys pointed out, well, he can't learn some subjects. That doesn't mean he can't learn. Maybe he should think about a field where that he can excel at. And his problem, I think, at least in significant part, is going to be that he has been able to take care of himself. Now here's where the rubber hits the road a little bit, though, is they do make reference in McGinnis that, and we've already talked about it a little bit, that in the past he has been able to mitigate his anxiety in chemistry and math by altering his study habits, which would make sense, right? The fact is, if you're supposed to wear glasses and you don't, so you now have difficulty seeing, well, I don't know whether that's a real disability. And the regulations talk about it as well. But here, he's been able to mitigate. The court says he should mitigate now, but the new changes do not take into account mitigation effects other than eyeglasses. I want to talk just quickly about the language in the earlier part that said the regulations make reference to. And I don't know how many times, I hope, they've made reference to regulations and the like with respect to your writing classes and all, to have you look for that and start to think about that with respect to especially these statutory or more modern violations. A lot of the activity that we need to get to look at may well be found not within the statute itself, but there oftentimes will be recommendations if it's supposed to be heard or an agency involvement, one of the state or federal government agencies, they will require that regulations be passed describing the types of activity as it said in that earlier paragraph. That's a really important source of information for you as the lawyer. If the Attorney General says, and we're going to look at this later in the semester, that this is the type of violations for consumer protection that we're looking at under Chapter 93A. Well, if the AG has regulations that further describe the types of unfair or deceptive trade practices, you need to be aware of that. And you need to be able to use that and call on that in deciding whether your client has a case. It's not just that. It talks about the language within the ADA as regulations. Same type of thing with respect to the MCAD's regulations on sexual harassment policies. There are a number of different agencies that pass regulations. It's not just a statute. that we use to help enforce our clients' rights. But oftentimes those regulations are really good sources of information and support for your case. For instance, auto accidents and standards of fault that are going to be found within the regulations is, who entered the intersection first and what, the point of collision. All of those things are oftentimes found in regulations as well, and you're going to use those regulations to support your client's arguments. Go ahead.
I just wanted to make the comparison that the court cited the Sutton case on McGuinness to define their major life activity, which the three-factor test that they use in McGuinness, Martin satisfies those three prongs that they said that an individual is substantially limited in a major life activity. One, if the nature and severity of the impairment, two, the duration or expected duration of the impairment, and three, the permanent or expected long-term impact of the impairment. So if we compare these two cases, McGuinness and Martin, Martin satisfies that, which would make him disabled, and McGuinness unfortunately failed those three prongs.
He can't really get to the point where we have to decide what's reasonable, because we don't see his learning disability, and I think it is harder than to see those physical limitations, but that he can truly show that it affects his ability to learn. It might affect his ability to learn certain material, difficult material, but we don't see how that's different than how we might have difficulty learning biochemistry or physics as well. There's language here, and I want to ask about it because it just strikes me as odd. He says something about that, well, I also have a child with cerebral palsy. I mean, is that just sort of thrown in there? Because I don't see where that's, I mean, it makes him a little more sympathetic, perhaps, that he's got a lot of things he's trying to handle. But how does that get him any closer to establishing he's got a disability, or he's got, he's associated with some form of discrimination there? Is that just you as the lawyer throwing things against the wall and seeing if things will stick? And because that seems kind of crummy to me. No,
I agree.
And so do we know why that's there, or is that just, go ahead.
I'm not sure why, but I would argue that maybe because sometimes with employers or like wherever you're working, that if they know you have a disabled child, then you have to take a lot of leave to help that child, like whether you have to take them to the hospital or you always have to, call in sick or something because you need to take care of the kid. So that but he couldn't prove that it was a determining factor in their decision to not let him pass.
Yeah, I actually think you're right, Geneva. I don't think it's just that he's thrown it in for sympathy. I think and especially in the circumstances you talked about, that even though he doesn't necessarily have the disability, if he's terminated or decisions affect him as a result of them seeing him being associated with that disability, then perhaps we have a slightly different result. But it doesn't seem like he's got any evidence to support it. It's just sort of thrown out there without any support for it all. A lot of these cases, Perez and this one, makes reference to we're talking about the magistrate. And we're going to see this again later on, but I want you to start to think about it from the standpoint in federal court. Most federal judges work directly with a magistrate judge as well. So that when you initially file your case, it is assigned in your docket number in federal court, has a judge's initials on it, and it's assigned to that judge. On a lot of discovery issues, even as we see in a couple of these cases, on the summary judgment arguments and the like, the magistrate judge would hear the case and make references to the judge. You have some control over that as the lawyer in deciding whether you want your case heard by the magistrate judge as well or the judge. It depends on who the magistrate is. And so just like we will research a judge, and we'll talk about that later on as well, you also want to research the magistrate that works with the judge as you start to think about making these decisions. Sometimes they'll even ask, well, do you want to try it before the magistrate judge first. Well, you know, the magistrate may well be, and oftentimes an experienced judge as well, but the fact is that the federal court judge is likely to have more experience and oftentimes therefore has seen many more cases and has a better understanding of how things work and the like. I just want you to start to think about is that the process in federal court is, even though it's assigned to a judge, there is a magistrate that oftentimes on discovery issues, on other less significant issues, may often be referred to the magistrate judge for his or her fact-finding and reporting first, and that can slow things down as well. You have some say over whether you want to go that process or not, and you want to start to think about how that potentially affects your case. If you're the plaintiff, as a general matter, speed is what's mostly important. I need to get to the trial date as quickly as possible, because the defendant's objective throughout is to delay, delay, delay. And so the sooner I can get to trial, all the better. Now, one argument will be, well, the magistrate will have a trial sooner than the judge. But that still doesn't mean necessarily that that's going to be the last word on it. So you want to start to think about that process and see where it goes. Let's talk a little bit about Toyota Motor Manufacturing, Kentucky versus Ella Williams. So what do you think about Williams? Is she just a slacker too? Oh yeah? So the guy who wants to play golf, he's not. He just wants to use that cart because he has to. But Williams doesn't want to do the difficult stuff on the line, and therefore we're not going to do anything for her either. Because it's a pretty harsh decision, isn't it?
She can brush her teeth.
She can brush her teeth. Who's going to pay her to do that?
Well, it says right in there that she can do daily activities because she can brush her teeth.
She can do her daily activities. By the way, here, yeah. Respondent based her claim that she was disabled under the ADA on the ground that her physical impairments substantially limited her in 1, manual tasks, 2, housework, gardening, 4, playing with the children, lifting, and working, all of which she argued constituted major life activities under the Act. In the alternative, she wants to be treated as having a record of a substantially limiting impairment because she's been regarded as such, so she should be continued to be treated as such. And since she's been treated this way, she feels that she has a claim of discrimination. So I can't simply fire you because you have a disability, correct? And if that's why, I mean, perhaps you don't even ask for an accommodation, but to some extent, if I just fire you because, as sort of the argument Geneva advanced, then that's actionable as well. Here, I've got her assigned to various tasks, and I think my recollection is she can do 3 of the 4, but she can't stand there all day with her arms over her head. Well, if you have physical limitations, we would have to agree that that has to be hard, right? I mean, if I asked you all to keep your hands up over your head for the remaining portion of the class, my guess is some of us would fail. Right? She's supposed to work the line with her hands over her head most of the day, moving heavy equipment around, even with assistance and the like. But she does have some physical limitations. Do we agree to that? I mean, she'd been out for a period of time. They moved her around a little bit from time to time. Do you think she's getting the short end of the stick too, or are you just convinced that she just wants it her way and no other way, and that's the way, and we can't do that?
I think the tendency is to believe that she's making some of this stuff up, you know, and if she's not, in fact, and if the evaluations or the medical evaluations are substantiated, I think you have to make accommodations for her.
But didn't they, even their own personnel department,
that's
determined that in part she was disabled from time to time, and hadn't she been out for a period of time? I mean,
But Toyota did accommodate her and give her an easier job for a period.
for a period.
And then they took her out of it, which I didn't understand. You know.
No, and then she stopped coming
Why
to
would they
work,
do
which is
that?
why they said they hired.
Well, okay, they were accommodating her, then they decided we're not going to anymore. Well, I think, you know what, because see, I wonder whether, Fred, that it was a policy decision. I've got, that has to be a difficult job. And if she doesn't have to rotate in, then that means Melanie's got to do Melanie's rotation plus Ella's. And I don't know whether you know Melanie, but sooner or later, she's going to be voicing some complaint about that. No, but right now, I have to police the whole floor. And that if half of you realize if I start complaining and asking for accommodations, I might get off of the most difficult part of the work, then there's going to be more people saying, hey, I got problems. I think in part they make a policy decision. They say, oh, we don't care. We can't, as a company, we can't do this and accommodate her anymore unless she's truly rock bottom disabled. And that means she just can't keep her hands up over her head. She can't, in order for her to be classified on the ADA as a disability, in essence, she can't use those hands at all. When we say work, we don't mean she can't do certain types of work. We mean she can't work. Yeah. Well, that's a little harsh, isn't it?
But I'm thinking, if you're hiring a particular job, the job has a certain requirements that come with it. You're supposed to be able to perform based on those requirements.
How long had she worked for Toyota? I thought it was like a really long
Yes,
time.
but then,
Well, I don't mean a while, sort of underly.
1990.
So 1990, and when was this?
97.
So half a dozen years she worked there. And Fiona says, but she can't do her job anymore. And so she's out. You, go ahead.
So then how would you,
Go ahead.
then how would you distinguish between, say, someone that's been working there a long time and just is older now and is having trouble holding their hands up and are complaining about it more? Who, would you keep one and not the other? Or like, is it, you know what I mean? Like you can, I mean, that's a hard job. I'm sure if I was doing it, I'd be complaining about it too. I just think that certain jobs do have certain requirements, and her saying that, you know, this carpal tunnel is causing her more pain, I mean, it's kind of the same argument as someone just getting older and saying, you know, my bones just hurt from like holding this stuff up. And them saying they can't do that. So how would you distinguish between the two, I guess is what I'm wondering.
Well, it's a very reasonable question. Well, I guess I'd look at the statute. Do we think that she has a physical limitation? I guess the old person would as well.
An age discrimination.
Well,
You can't discriminate because of someone's age.
well, but she, Alina's point is I'm not discriminating. I'm saying you can't do the you can't do the job anymore. I don't care that you've been here 40 years working for the company. You're out. You're done. Goodbye. It has nothing to do with you being old. It has the fact that you're old and can't do the job. You're right. No.
The job was the cause of the injury, really.
Well, but if the job is the cause of the injury, we have another statutory remedy, which is generally going to be workers' compensation, right? And so we'd be going that route, and she's going to get compensated. So if the job, but I think in part the job may well have contributed to it, but then she should be pursuing workers' comp. But she's got physical limitations. Well, let me ask you guys, because I'm doing a very poor job. Her question is, physical limitations caused by disability or age, what difference does it make? At some point, unless they affect a major life activity, you're done. And frankly, some of the early language we read says, and if it just happens when you're old, you don't even have a history of it, so maybe you're just old, and it's time to move on. So would you make a distinction in that or not? Listen, I don't have the strength in my upper body that I had before, so I can't keep my arms up. And I could be 30 as a result of a disability doing it, or I could be 65 and just old. And at the end of the day, it doesn't matter.
Yeah, that's harsh, and I was torn with
Yeah.
this whole case. so I wasn't really sure, but then, I mean, it just comes down to, I guess, you know, I can't be a flight attendant because I'm under 5'6", so.
Is that true?
Yeah.
Oh, really?
You have to reach the overhead.
Right.
Is that what it is? Better choice, by the way.
No, but I mean, you know, it's just fact. I can't.
Yeah.
What am I gonna do?
Well, let me ask about that in the same vein, right? I'd like to be a fighter, but I can't lift 200 pounds. So, you want me dragging your ass out of the house, it's just not going to happen. So, but maybe we'll figure out a way to get you out of that burning house anyway. Is that true, though? Is that it's fair for companies? I mean, because again, my guess is looking at your doctor situation, you're going to want the fireman, you're going to want Buck Rogers busted in your window dragging your ass out of that house when it's on fire, right? I don't want some. Well, let me ask that. It sounds horrible as I started to say it. I don't want some disabled person who can't lift a certain amount of pounds trying to carry me out of a house that they have difficulty walking out of the house. That it is appropriate, it's permissible that the company be allowed to set specific physical requirements for the jobs that need to be performed, as long as, and I'm going to just add this to it, as long as you can show that they are a necessary part of the job, right? And that we should have talked a little bit about McGinnis as well, because the same thing for a law school, for med school. You know, if you want to say you've got to pass, you know, pick a course that you would say a doctor doesn't need, you know, advanced political science, and this guy can't do it. Well, then we might be arguing about whether that's essential to the job. Same thing for law school, right? If I wanted you to pass a physics course, you might argue, well, listen, I can't pass physics, but as a lawyer, I'm never going to use physics. But if you can't pass con law, well, that's a pretty essential qualification of being a lawyer, to at least have some knowledge about it. And I do think, and we didn't talk about it, but there is this notion out there that the educational institutions, as well as the employer, can set basic qualifications. What about that? That's okay? Go ahead, Jeff, right?
John.
Oh, John.
They talked about that in the Martin case, too.
Yes.
When they were talking about fatigue, the question was, is this an essential part of the game?
Right.
And I think that that's a good standard to have.
So what about this, then? So this is just all they're doing? So it doesn't make a difference whether you're young or old. If you can't raise your hands up for more than 4 hours at a time, if you can't carry 200 pounds out of a second floor of a building, you're not otherwise qualified. You're not able to do the job. We don't have to get to accommodation.
But we're arguing on the premise that they fired her because she couldn't do the job, and they claim otherwise. And in the case, they tell us that there's a disagreement, that she claims that she said she could do the job without, you know, the first two parts.
Yeah, she says I either 2 or 3. I think she says I can do everything but this part of the job, right? And they're saying, but that's an essential part of the job as well. You don't get to say.
They're not saying that. They're saying the parties disagree about what happened next. They're saying Toyota says then she stopped coming to work.
Right.
Right.
Well, she did though.
Yeah, but maybe they were giving her that up. They're claiming, I think, that they were going to let her just do those.
Oh, see, I didn't read it that way. I think Toyota was drawing the line saying, we need you to do all 3. And 2 out of 3 is no good because, and I think it was a policy decision because I've got then all these other folks saying, I don't want to do that part, I don't want to do that job 1/3 of the time. I certainly don't want to have to do it 2/3 of the time. You don't think?
No, I mean, if you read the language, it says the parties disagree about what happened next. According to respondent, petitioner refused her request and forced her to continue working in the shell body audit job. According to petitioner, respondent simply began missing work on a regular basis, regardless, the court says.
Yeah, but see, I don't think those are inconsistent. I mean, I think that she did. I think she saw it, they're going to make me do this 3rd job, and she saw it as, well, I'm just not going to come to work anymore. And by the way, that type of situation happens a lot in these cases as well, where you've got, you know, this harassment or discrimination, and then the argument is fired or quit. And, you know, the argument is constructive discharge or walked away from the job. So that's not uncommon that we would fight about that as well. I think, and I've always read it this way, is they're in essence saying, you know, you got to do all three, and if you can't do all three, then you're not qualified to do the job, and you can't work here anymore. And what I think the case, as they work through it, says, no, working means working. It doesn't mean if she can do 2 of the 3, that by her own admission she can work, she just can't work at this job anymore. And I think that's where we end up. But that's what Toyota really comes away with, that working means working. It means if you can flip burgers, then go flip burgers. It means if you need to study sociology and poli-sci instead of biochemistry, find what you're good at. But you're obviously not good anymore at working the line. That's it, Fiona. But out she goes. Go ahead.
Did they try putting her elsewhere in the company, or maybe a job with instead of using the hands, if she was on the line, the assembly line, using a pedal, a foot pedal, or something with her feet? Because in the McGinnis case, they quoted the McDonald versus Delta Airlines, and it says in McDonald, the airline mechanic whose vision impairment prevented him from taxiing the aircraft was found not to be disabled under the ADA because he could do many other jobs. So I mean, why couldn't they put her elsewhere? They didn't require her to do that.
I think, go ahead.
Oh, I was going to say, I don't know about that case, but it may be because they had the ability to put him elsewhere, and in this case, they didn't have any other open jobs to put her in, because she was in something else and they moved her for a reason. So it might just be that they didn't have somewhere else to go. They can't kick someone else out of their job just to make an accommodation for her.
Well, how many of us would want to stand like this all day, given a choice to do anything else within the company? Very few of us, right? And that's why I think, in part, the notion that they said, she's probably closer to right. We don't want you here anymore. We're not going to go find a cushy job. We want you to either work the line, that's what you were hired for, or we're done. And I think the concern is, well, I've got a factory full of people. No one's going to want to do that job. And so they held on their own. Go ahead.
Oh, but I think the companies are leery of these kind of suits, though. So wouldn't they, if they really did think she had a valid claim, wouldn't they be hesitant? Wouldn't they likely move her rather than, you know, have this suit?
Well, I could, but then I'm going to move Melanie.
But that's because they don't think she has a valid claim.
Well, but she's got carpal tunnel, right? She's got. I think the evidence indicates she's got physical limitations.
Right.
No, right?
Right.
So it's not one of these, what we think as well, this is just all made up. Huh?
Not enough to seek, you know, compensation under the ADA. I mean, that's what.
Well, but not enough under the ADA, I think, and this is why I think it's an interesting case, means if you can do something, you're okay. Move on. Right? I mean, because they're not saying, well, she can do, they say I think that's what they say. She can do something. If she can work at anything, she doesn't have a limitation that affects a major life activity. It's pretty harsh.
It is, but I think that the case comes down to the definition of what is disability under the ADA. And I think on her own words, by saying that I can still do the other two, she's qualified herself as someone disabled under the ADA.
And so the company doesn't have any obligation to find her a job that's more suitable to her physical limitations.
Was she under contract? I mean, if she's an employee at will, they can fire her for any time, any reason whatsoever.
I think she's an employee at will, and she's saying, she's hoping that the ADA will cover her because she does have some physical limitations. I think I would concede that if I'm Toyota. But I think they decide they're going to stick their flag in this and hold their ground and say, yes, she's got some limitations. Yes, she's had some surgeries and the like. But if she can work, then she needs to work the tasks we assign to her, and she doesn't get to pick and choose which ones of those she doesn't like.
Toyota what?
Okay, and they do. Let me go back to Alina's question then. So, same thing with old people? I'm not firing you because you're over 50. I'm firing you because you can't keep your hands up over your head.
Don't you have to in order to?
Don't you have to what?
Lose you know, in order for your company to be successful, I mean, that's.
Well, right, who's gonna do this? So I can fire the older person, not because they're old, but because they have physical limitations that mean they no longer can do the job. And it's just business, because I gotta run a shop here. Well, if you're the 50-year-old person, you're not necessarily gonna see it that way. No, but it is what it is. So if you're representing the employer, you're gonna tell them they better document what the requirements are for performing the job, and make it clear that whether you're 20, 40, 50, or 60, that this is what's mandatory that you do. So there would be no claim. Someone goes into a company at 20, works for them for the next 35 years. 55 years old, my doctor says I just can't keep doing this anymore. It's ruining my shoulders. It makes me tired.
That's why you need to own the company.
Yeah, but you know, there's an awful lot of factory workers that'll never own the company. There's an awful lot of people working somewhere that, I need this job. And I don't think you want to be 55 without work either. But that person can go, and there's no suit coming. Yes. Right? Is that right? I mean, not everything is going to be covered by the ADA. Not everything is going to be covered by age discrimination. The companies, and especially thinking about this case, they have the right to set baseline requirements for job performance, and if you can't meet them, just because you're in a protected class doesn't mean you have a claim either. Right?
But there needs to be, you know, there's got to be a minimum of, you have to be able to do the job and function in it. And we all have some personal responsibility. Those of us who work in physically intensive jobs, be aware that as you get older, you got to think about what's plan B. And once you get to that point where you can't physically do the job. Unless
Yeah, that's fair. It's a fair comment, right?
Isn't it the same as far as mental impairment as well as physical? And that's covered in the ADA as well. What if you, as an attorney, you have a little bit of dementia? Should the firm keep you on, or?
Isn't that a disservice then to the clients?
Well, of course it is. It's a potential malpractice and everything else. So physical and mental, if
Isn't that the same argument?
you're not on the ball, out you go.
What if you're working on?
Maybe harder to prove the mental impairment sometimes.
Right.
But right, it's still,
You're a factory and you're not putting the tire on correctly because of your physical impairment. That's the case there as well?
yeah, you know what, and I agree with you completely. It's just funny when it was put that way. So the argument is, I mean, the likelihood is that at some point as we age, our physical limitations will become such that you have to leave the career that you have established. And you've got to have a plan B, just what you said. Interesting. I mean, I never quite thought I thought of it as you're going to need to leave because they're going to be able to dump you. Go ahead, and then I'll come over.
The company's there to make money, and your productivity has to do with the company's ability to make sufficient money to pay you. So if you're going to be there and for the day you're going to make one little tire, I mean, and while somebody else who's younger or more able is going to make 10, what's the sense of keeping you? Because you have, you cannot do the entire functions that the job requires. But I feel, in a lot of ways, that's unfair to keep you on.
It's capitalism, right? Do the job, or be gone. And there's no claims, regardless of the class you may fall in. Go ahead, Janina.
I was just going to say, some jobs have mandatory retirement, so there are legal ways of looking at someone and saying, you're at this age, you're done. You basically
I mean, what does he get for his 35 years of service, though? Does he get a severance package? Does he get entitlement to 401k? Does he get,
That's a whole other issue. I should put a weekend on that. Really, all these retirement plans that are going belly up because the company decides to take advantage of various legal maneuvers and disavow the pension plans and the like. So I don't know. It's obviously going to depend on the company, but there's not always a pension plan, right? So go ahead.
Well, the same argument can look at the other side. As a younger person can say, well, this old guy cannot do the job. I didn't get hired, but you make an accommodation to him to keep his job. So I can, when you switch the requirement, you open the doors for other laws to that as well. I can say, well, only for treatment, I didn't get hired, and this guy making accommodations, but because of his age and so forth. So I think there has to be a set of requirements. Say, well, you cannot do the job, so for you to move on. You know, it's the fact of the world.
Well, see, I mean, and that now let's take it from the other standpoint. So if you're representing the company, you know that there's a whole bunch of lawyers out there looking for those discrimination claims, whether it's disability or age or gender. You better probably have some pretty well-established requirements that are enforced relatively evenly, right? Because if not, then I'm still going to be able to say, well, you singled me out, but there's another guy or the woman who's similarly situated, you didn't treat her this way. So from the standpoint of, if we're going to try and avoid some of this litigation, if we're representing the company, then we better be prepared to not only have helped shape those policies, but then make sure that the company understands that they have to be, likely have to be enforced consistently if they want to avoid this, because someone is still going to feel that they've been singled out for discrimination. And I guess I just don't want to get past it. So business is business, and the law is the law. And, you know, you don't feel that bad about Toyota because she can't do it. So I always read this case as kind of harsh. I mean, Toyota manufacturing, they can't find another spot she can do. But working is working, and if she can do any work, she doesn't get a guarantee of doing only the work she likes for the company. And she's out. Go ahead.
Well, I think some forms of work, like moving, they will really destroy your body over time. And so I wonder if there's a possibility for, like you were saying, workers' compensation claims.
Oh yeah, if you can show that you were injured as a result of the employment, then you do have a workers' compensation claim. Even if it... I'm sorry?
She filed 2 claims against
right.
And one of them was for workers' comp, which they settled, and then she filed another one under the ADA, which was also settled too. She's almost like liability to Toyota as well, because she keeps filing claims against them.
Well, see, that's why I disagreed with Karen. I think they finally said, listen, she's going to cost us money either way. Let's cut our ties and let's be done with her and stop paying her, because the more employment she gets, she sues us, and it costs us money both ways. And so I do think they drew a line in the sand and said, we're going to be done with her. We're going to pay the lawyers some money. And I mean, listen, they took it all. This is not an inexpensive case to litigate. They took it all the way to the Supreme Court of the United States over what it clearly had to cost them nearly as much for lawyers as it would have cost to pay her next suit. But they might have saw it as, so we pay the next one, she comes back, and we pay the next one. I mean, this is not the ideal employee to have in the shop. I'm not going to do the job that Melanie has to, so now Melanie's got to do that, and every time I turn around, she's filing a suit for something, and she's making money off. She's making money out of this. We settled her workers' comp, we settled her ABA. Let's see if we can sever ties and set a rule that hopefully will make our shop run more efficiently. And I think this was a policy decision by them. And I think in part it was a policy decision by the Supreme Court. And maybe, I don't know what the motivation was, but the Supreme Court to say, listen, we're going to say working means working means working. And if she can work at all, then that's not a disability. And I think in part it was Toyota that pushed Congress to take another look at the Act and to try and fix what they saw as some of what Congress saw as some of the loopholes within it by making some of these changes. Let me just hit EEOC quickly. Equal Employment Opportunity Commission, another federal agency that you can bring some of your claims to. EEOC will investigate these claims and can then issue a report that may be supportive of your rights as well. So you want to think about that agency. The two big ones here it will be EEOC and the MCAD, Mass Commission Against Discrimination and Equal Employment Opportunity Commission. And what they're suggesting here is that the fact that the employee has agreed to arbitrate, which, by the way, a lot of employment agreements now, and not contracts per se, because it's not that you're a contracted employee guaranteed anything, but as part of your opportunity to work for the company, you're going to sign away huge amounts of rights, likely not being able to go to court at all, but agree to arbitrate any dispute, and not pursue certain administrative rights that you have as well. The case was an interesting case as well, I think, if you looked at it quickly, because it said, well, while the person might be able to go that route, it doesn't mean that EEOC can't still investigate these claims and potentially seek relief on behalf of those folks. It also makes reference to, I think, an important act that you should be aware of, which is the FAA, the Federal Arbitration Act. And if you actually went and did some research on the Federal Arbitration Act, what you would find is that the federal courts significantly favor the arbitration of disputes. And so all the cases, as well as the Act itself, talks about broadly construing these provisions in agreements. And so it's really quite difficult to overcome the arbitration agreement, even though the person has likely waived their right to a jury trial, waived their right to go to their local court, and is now required to litigate the matter by way of an arbitrated decision. And what the FAA does provide, though, is for a stay of proceedings in federal court. So if one party does file the action in federal court, then you can actually seek a stay of that action if there was a provision in the contract requiring the parties to arbitrate the dispute. And that, in fact, is what the Waffle House's agreement did. And so because they were required to arbitrate it, that didn't bar EEOC from pursuing remedies on its own as well. So as you start to think about how these work in the workplace, what you're going to find is that the modern trend is to have a lot of these situations covered by arbitration agreements and the like, making it further difficulties to try and recover the damages or to pursue those types of claims. On Section 3, which is then, first part of Section 3 is for Thursday. I'm going to be in New York, so what you're going to do, whether you do it here or wherever, is there's a PowerPoint presentation on the discs for this class, and there's 103 questions that go with it with respect to CivPro and various choice of law issues and things like that. I think it's a good place for you to start to try and make sure we're all on the same page. Some of you have seen it and done it before. But there'll be questionnaires outside my office. If you're intending to come here, they'll have the disc playing here on Thursday at 4:30 with some of the questionnaires, but I'll also have some of the 103 questions put outside my office. But it doesn't make a difference. If you've got the disc, you don't have to do it here. You can do it at your computer terminal. But I think it's important that you take a look at the PowerPoint presentation again. You go over the 103 questions so that as we see a lot of the procedural things that come up through the course of these cases, we can talk about them a little more in depth. I thought what was interesting, and I wanted to focus on it a little more, but we have a set class to do it later on. In that Perez case, and there's some extra cases if you didn't get it already, they go through the process, really the modern process of how summary judgment works in federal court. And it's actually kind of detailed and involved, where it's the moving party has to file a motion with the supporting affidavits and the statement of uncontested facts. The adversary then has to respond to those uncontested facts. We're going to talk about it a little later on, but it is a significant and time-consuming process. And you might want to look a little bit as to how it actually works, because I think we get some insight into Perez. But it is an incredible amount of work to oppose and to move for summary judgment. I think for two reasons. The court wants to ensure that people just don't send in a summary judgment motion without really thinking it through. And at the same point, the court wants to have the ability to weed out some cases, a lot of cases, that it doesn't choose to give to a jury trial. And so this process about filing statements of uncontested facts and then supporting your opposition to that, and not just saying we object that that fact isn't true. They want references from the depositions that were taken in the case, from documents that exist in the case, They want to not just know you dispute it, but they want to see where your evidence is that disputes it. So summary judgment, in many cases, not even a complex case, but rather if it's a large case where there's a lot of money at stake, that in and of itself can come to a tens of thousands of dollar process to be able to move and then oppose summary judgment, because the nature of the documents that have to be submitted in that process and the amount of work that goes into creating a comprehensive both motion for summary judgment as well as the opposition to it. Questions? I'll see you next Tuesday. Okay, thank you. So Melanie, what do you need?
My boss.
Let me check on the traffic. I'm going to put them down. She should have some in the main office, and I'll bring them up.